Hello dear students, the topic that we are going to study today is modes of dissolution of partnership firm and the consequences on dissolution of partnership firm. Before we study the topic, let us know what is partnership and its characteristics in brief. What is partnership? Partnership is the relation between persons who have agreed to share the profits of a business carried on by all or any one of them acting for all. It therefore follows that a partnership consists of three essential elements. First, it must be a result of an agreement between two or more persons. Second, the agreement must be to share the profits of the business. Third, the business must be carried on by all or any one of them acting for all. All these essentials must coexist before a partnership can come into existence. For example, a manager as a part of his remuneration may be given a share in profits of the business. He does not thereby become a partner. It is not quite easy to define the term partnership. The definition given by Section 4 of the Partnership Act brings out very clearly the fundamental principle that each partner, when carrying on the business of the firm, is an agent as well as the principal, and is probably the most business-like definition of the term. The definition contains three elements which must be present before a group of persons can be held to be partners, namely agreement among all the partners, agreement to share the profits of the business must be carried on by all or any of them acting for all. These three elements may appear to overlap, but they are nevertheless distinct. The element of agreement in partnership distinguishes it from various other relations which arise by operation of law and not from agreement such as joint owners, Hindu undivided family, etc. We shall now consider the aforestated essential elements one by one. Agreement. You have just observed that partnership must be the result of an agreement between two or more persons. You should note that it can arise only from a contract and not from status. That is why a partnership is distinguishable from a Hindu undivided family carrying on a family business. The reason is that as a result of the peculiarities of Mitakshara school of Hindu law applicable to joint families, a male child of a Hindu acquires an interest in a family business even in the absence of an agreement in their behalf, whereas partnership is a creation only out of mutual agreement. Thus, the nature of partnership is voluntary and contractual. An agreement from which relationship of partnership arises may be express. It may also be implied from the act done by partners and from a consistent course of conduct being followed, showing mutual understanding between them. It may be oral or in writing. Sharing profit of business. In this context, we will consider two propositions. First one, there must exist a business. For the purpose, the term business includes every trade, occupation and profession. The existence of business is essential. The motive of the business is the acquisition of gains, which leads to the formation of partnership. Therefore, there can be no partnership where there is no intention to carry on the business and to share the profit thereof. For example, co-owners who share amongst themselves the rent derived from a piece of land are not partners because there does not exist any business. Similarly, no charitable institution or club may be floated in partnership. A joint stock company may, however, be floated for non-economic purposes. Secondly, there must be an agreement to share the profits. For example, X and Y buy certain bales of cotton which they agree to sell on their joint account and to share the profits equally. In these circumstances, X and Y are partners in respect of such cotton, but an agreement to share losses is not an essential element. However, in the event of losses, unless agreed otherwise, these must be borne in the profit sharing ratio. The business carried on by all or any of them acting for all is another essential condition. This is the third requirement, that the business must be carried on by all the partners or by any one or more of the partners acting for all. This is the cardinal principle of the partnership law. An act of one partner in the course of the business of the firm is in fact an act of all the partners. Each partner carrying on the business is the principal as well as the agent for all the other partners. You should therefore note that the true test of partnership is mutual agency rather than sharing of profits. If the element of mutual agency is absent, then there will be no partnership. Sharing of profits is only prima facie evidence, which can be rebutted by stronger evidence. Thus, this prima facie evidence can be rebutted by proving that there is no mutual agency. Now, let us study the meaning of dissolution of partnership firm. Dissolution of partnership firm is dealt in the Partnership Act from the sections 39 to section 47. According to section 39 of the Indian Partnership Act 1932, the dissolution of partnership between all partners of a firm is called dissolution of the firm. Thus, the dissolution of firm means the discontinuation of the jural relation existing between all the partners of the firm. But when only one or the partners retires or becomes incapacitated from acting as a partner due to death or insolvency or insanity, the partnership, that is, the relationship between such a partner and the others is dissolved, but the rest may decide to continue. In such cases, there is, in practice, no dissolution of the firm. The particular partner goes out, but the remaining partners carry on the business of the firm. It is called as dissolution of partnership. In the case of dissolution of the firm, on the other hand, the whole firm is dissolved. The partnership terminates as between each and every partner of the firm. There are various modes of dissolution of partnership firm. Let us study them in detail. Now let us study the modes of dissolution of a partnership firm. The dissolution of partnership firm may be done in various ways. The first one is dissolution without the order of the court or voluntary dissolution. It consists of four various types. First one, dissolution by agreement. A firm may be dissolved with the consent of all the partners or in accordance with the contract between the partners. B. Compulsory dissolution. A firm is compulsorily dissolved by adjudication of all the partners or of all the partners but one as insolvent, or by happening of any event which makes it unlawful for the business of the firm to be carried on. For example, a firm is carrying on the business of trading a particular chemical and a law is passed which bans on the trading of such particular chemical. The business of the firm becomes unlawful and so the firm will have to be compulsorily dissolved. C. Dissolution on the happening of certain contingencies. Subject to contract between the partners, a firm can be dissolved on the happening of various contingencies, like where the firm is constituted for a fixed term on the expiry of that term, where the firm is constituted to carry out one or more adventures or undertaking, then by completion thereof, on the death of a partner and on the adjudication of a partner as an insolvent. For example, where a partnership was constituted for a fixed term or for carrying out a particular adventure or undertaking the death or insolvency, does not dissolve the partnership firm unless there is any contract to the contrary. D. Dissolution by notice of partnership at will. Where the partnership is at will, the firm may be dissolved by any partner giving notice in writing to all the other partners of his intention to dissolve the firm. If the date is mentioned, the firm is dissolved as from the date mentioned in the notice as the date of dissolution, or if no date is so mentioned, as from the date of the communication of the notice. The second way is by dissolution by the court. The court may, at the suit of the party, may dissolve a firm on these grounds. First one, insanity or unsound mind. Where a partner has become of unsound mind, the court may dissolve the firm on a suit of the other partners or by the next friend of the insane partner. B. Permanent incapacity. When a partner other than the partner suing has become in any way permanently incapable of performing his duties as partner, there the court may dissolve the firm. C. Misconduct. Where a partner other than the partner suing is guilty of conduct which is likely to affect prejudicially the carrying on of the business, the court may order for dissolution of the firm by giving regard to the nature of business. D. Persistent breach of agreement. Where a partner other than the partner suing willfully or persistently commits breach of agreements relating to the management of the affairs of the firm or the conduct of its business, or otherwise so conduct himself in matters relating to the business that it is not reasonably practicable for other partners to carry on the business in partnership with him, there the court may dissolve the firm at the instance of any of the partners. For example, if one of the partners keeps erroneous accounts and omits to enter receipts, or if there is continued quarrels between the partners, or there is such a state of things that destroys the mutual confidence of partners, the court may order for dissolution of the firm. E. Transfer of interest. Where a partner other than the partner suing has transferred the whole of his interest in the firm to a third party, or has allowed his share to be charged or sold by the court in the recovery of arrears of land revenue, the court may dissolve the firm at the instance of any other partner. F. Continuous losses. Where the business of the firm cannot be carried on except at a loss in future also, the court may order for its dissolution. G. Just and equitable grounds. Where the court considers any other ground to be just and equitable for the dissolution of the firm, it may dissolve a firm. There are various cases for the just and equitable grounds. First, deadlock in the management. Second, where the partners are not in talking terms between them. Third, loss of substratum. Fourth, gambling by a partner on a stock exchange. These were the various modes of dissolution of the firm that we studied. Now, let us study the consequences of the dissolution in brief. Thus, the consequences of dissolution of a partnership firm. The partners have certain rights and liabilities that we will be discussing. First, let us study the rights of partners on dissolution. Right to enforce winding up. On a partnership being dissolved, any partner or his representative shall have right against the others to have property of the firm applied in payment of the debts of the firm, and to have the surplus distributed amongst the partners or their representatives according to their respective rights. Extent of continuing authority of the partners after dissolution. The authority of a partner to bind the firm and other mutual rights and obligations continue so far as may be necessary to wind up the firm, to complete the unfinished transactions pending at the date of dissolution and no other. Personal profits earned after dissolution, where a firm is dissolved by the death of a partner and the surviving partner or the surviving partners along with the representatives of the deceased partner carry on business of the firm. Any personal profits by them before the firm is fully wound up must be accounted for by them to other partners. Thus, a lease expiring on the death of a partner which is renewed by the surviving partners before final winding up belongs to the partnership. This section has to be read with section 53, which provides that in the absence of an agreement to the contrary, each partner or his representative is entitled to restrain other partners from carrying on a similar business in the name of the firm or from using the property of the firm for their own benefit till the affairs of the firm are completely wound up. Return on premium of partnership's premature dissolution. According to section 51, in the case of dissolution of a partnership earlier than the period fixed for it, the partner paying the premium is entitled to the return of the premium of such part thereof as may be reasonable, regard being had to the terms of agreement and to the length of the time during which he was a partner, except when the partnership is dissolved by the death of one of the partners, mainly due to the misconduct of the partner paying the premium, pursuant to an agreement containing no provisions for the return of the premium or any part thereof. For example, X and Y become partners for 10 years. X pays Y a premium of rupees 2000. At the end of 8 years, a quarrel arises between X and Y and a dissolution is declared. In such a case, X will be entitled to a return of such amount of the premium from Y as may be deemed reasonable. What is reasonable will depend upon the circumstances of each case. The partner paying the premium gets a proportionate part of the premium where the partnership is dissolved, without the fault of either party or owing to the fault of the both, or on account of the fault of the partner receiving the premium due to the insolvency of the partner receiving the premium, where the partner paying the premium was unaware of the other's embarrassing circumstances at the time of entering into the partnership. Rescission of partnership for a fraud act. A partnership agreement is a contract basis on amount of confidence. In the case of fraud or misrepresentation practiced by one partner or the other, the party misled has the right to resign the partnership agreement and is entitled to a lien on the surplus after payment of firm's debts for any sum paid by him for purchase of a share in the firm or for any capital contributed by him, to rank as a credit of the firm in respect of any payment made by him towards firm's debts, to an indemnity from the partners guilty of fraud or misrepresentation against all the debts and liabilities of the firm, right to restrain from use of firm name or firm property after the firm is dissolved. Every partner may restrain any other partner from carrying on a similar business in the firm's name or from using any of the property of the firm for his own benefit until the affairs of the firm have been completely wound up, unless a partner has purchased the goodwill of the firm. Right where partnership contract is rescinded for fraud or misrepresentation, where partnership is rescinded on the ground of fraud or misrepresentation of one of the partners, the partner entitled to rescind has various rights. First one, right to lien on the surplus assets. He has a lien on the surplus assets after the debts of the firm have been paid for any sum paid by him for the purchase of his share in the firm and for any capital contributed by him. Right of subrogation. If a partner pays off a creditor from his own pocket, he steps into the shoes of that creditor and can claim money from the firm as that creditor. Right to be indemnified. He also has a right to be indemnified by the partners or partner guilty of fraud or misrepresentation against all the debts of the firm. Now, let us study the liabilities of the partners. On dissolution, continuing liability until public notice. In spite of dissolution of the firm, partners continue to be liable for any act done by any of them, which would have been an act of the firm if done before dissolution until public notice is given of the dissolution. For example, X and Y, who carried on business in partnership for several years, executed on December 1 a deed dissolving the partnership from the date, but failed to give a public notice of the dissolution. On December 20, X borrowed in the firm's name a certain sum of money from R, who was ignorant of the dissolution. In such a case, Y also would be liable for the amount. To this rule, there are some exceptions. Even where notice of dissolution has not been given, there will be no liability for subsequent acts of other partners in the case of, first one, the estate of a deceased partner, second, an insolvent partner, or C, a dormant partner, that is a partner who was not known as a partner to the person dealing with the firm. Second one is settlement of partnership accounts. In settling the accounts of a firm after dissolution, various rules laid down by section 48 of the Indian Partnership Act, subject to an agreement by the partners, must be observed. First one, losses including deficiencies of capital are to be paid first out of profits, then out of capital, and lastly by the partners individually in the proportions in which they were entitled to share the profits. For example, X and Y are partners sharing profits and losses equally, and X died. On taking partnership accounts, it transpired that he contributed 6,600 to the capital of the firm and Y only 400. The assets amounted to 2,000. The deficiency was 6,600 plus 400 and less 2,000, that is 5,000 rupees, which would have to be shared equally by Y's and X's estate. If in this case the agreement was that on dissolution the surplus assets would be divided between the partners according to their respective interest in the capital, and on the dissolution of the firm a deficiency of capital was found, then the assets would be divided between the partners in proportion to their capital, with the result that X's estate would be the main loser. It may be noted that prima facie accounts between the partners shall be settled in the manner prescribed by partnership agreement. The aforesaid rules apply subject to any agreement between partners. The rules laid down in section 48 as to what will be the mode of settlement of accounts in the usual course of business. But if the partners by their agreement express any different intention as to the mode in which losses will have to be borne eventually, or the manner in which capital or advances will have to be paid to any partner, such an intention must be given effect to. However, any such agreement cannot affect the rights of the creditors of the firm. The assets of the firm, including any sums contributed by the partners to make up deficiency of capital, must be applied in various manner and order. In paying the debts of the third parties, in paying to each partner rateably what is due to him from the firm for advances as distinguished from the capital. Third one, in paying to each partner rateably what is due to him on account of capital. And fourth one, in distributing the residue, if any, among partners in the proportions in which they were entitled to share profits. The significance of the foregoing provisions is that if the assets of the firm are not sufficient to pay off the liabilities of the firm, including the amount due to each partner on account of capital, each partner would individually be liable to contribute towards the losses, including deficiencies of capital in the proportion in which he is entitled to share the profits. Suppose A, B and C were partners under the agreement that they were to share equally in the profits and losses of the firm. In a suit between them for dissolution and accounts, it is ascertained that contributions of A, B and C to the capital of the firm were 10,000, 5,000 and 1,000 respectively. The assets of the firm after paying debts of the firm and advances made by the partners as distinguished from their contributions to the capital of the firm are 7,000. The deficiency of capital, which must be regarded as loss, being 9,000, each partner must contribute to the assets an equal share of the deficiency, that is 3,000. After this is done, the assets then available, 16,000, will be distributed among the partners with the result that each will have suffered a loss of 3,000. In actual practice, it will not be necessary for A and B to pay rupees 3,000 each, but the matter will be settled on the basis of notional contributions, so that C, whose capital is 1,000 only, will pay 2,000 out of 9,000 with the firm. A will take 7,000 and B 2,000. Assuming that A and B contribute to the capital deficiency 3,000 each and C cannot, A and B will share 13,000, that is 7,000 plus 6,000 in the proportion of 10,000 is to 5,000. A will suffer a loss of 4,333 in all and B will suffer a loss of 3,667, where there are joint debts due from the firm and also separate debts due from any partner. The property of the firm shall be applied in the first instance in payment of the debts of the firm, and if there is any surplus, then the share of each partner shall be applied to the payment of his separate debts or paid to him. The separate property of any partner shall be applied first in the payment of his separate debts and surplus, if any, in the payment of debts of the firm. In terms of section 51, the partner paying a premium on entering into a partnership for a fixed period becomes entitled to the return of an appropriate portion of the premium. Therefore, dear students, in today's lecture, we studied what is partnership, we studied what are characteristics of partnership, we studied modes of dissolution and what are the various consequences on dissolution of a partnership firm. Hope you have understood the details. Thank you so much. Have a great day.